This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why an insurer should never be required to take on the burden of the insured's fraud, and why rescission as an equitable remedy is appropriate when an insured lies on the application for insurance. Progressive Michigan Insurance Company appealed the order denying its motion for summary disposition and reformation of plaintiff Janice Sherman's automobile insurance policy, even when reformation was not even requested by Sherman. In a case called Janice Sherman versus Progressive Michigan Insurance Company, a June 20, 2024 decision of the Court of Appeals of Michigan, the Court of Appeals explained the importance of the equitable remedy of rescission. On November 12, 2020, Sherman applied to Progressive for a no-fault insurance policy for two vehicles, a 2006 Cadillac DTS sedan and a 1993 Chrysler New Yorker sedan. In the application, she identified her address as 16845 Tremlett Drive in Clinton Township, Michigan, and confirmed that the vehicles were garaged at that address. The application also failed to disclose the total number of resident relatives, 14 years of age or older, and all regular drivers of her vehicle then residing in her household. Progressive litigation underwriting specialist Janine Kopic submitted an affidavit stating that Progressive would have charged a 7.7% higher premium had Sherman accurately disclosed the number of drivers and resident relatives at the reported address, and a 75.5% increased premium had Sherman disclosed her permanent Detroit residence. On July 14, 2021, Sherman was a passenger in one of the vehicles when it was hit from behind by John Doe. She was injured in the accident and asked Progressive for personal protection insurance PIP benefits. Progressive refused while rescinding the policy ab initio, that is, from its inception, because of misrepresentations in her application. Sherman had lied about the location where the cars were garaged, and other individuals resided with her who she did not list on the application. Progressive estimated that had Sherman included this additional information, it would have increased her premium by 83.2%. Sherman then, of course, sued Doe and Progressive, claiming Progressive unlawfully refused to pay PIP benefits and had breached her insurance contract. Sherman claimed the remedy should be tailored to the equities of the situation and needed to produce a fair result for all parties. The trial court ordered that the policy be reformed to reflect the insurance premium that Progressive believes it would have been entitled to had the insured listed Detroit as the residence, forgiving thereby her fraud and giving her the insurance as long as she paid additional premium. Summary disposition, or what most states call summary judgment, is appropriate if there is no genuine issue regarding any material fact and the moving party is entitled to judgment as a matter of law. An insurer has a reasonable right to expect honesty in the application for insurance. Indeed, it is well settled in Michigan and just about every place else in the United States that an insurer is entitled to rescind a policy ab initio on the basis of a material misrepresentation made in the application for no-fault insurance. A misrepresentation is material if the insurer would have rejected the risk or charged an increased premium and would not have issued the same contract had it been given correct information. Even if fraud was not established, rescission is justified in cases of innocent misrepresentation if a party relies upon the misstatement because otherwise the party responsible for the misstatement would be unjustly enriched if he were not held accountable for his or her misrepresentation. There was no reason in law or policy for the burden of such a risk to be placed on the insurer in preference to the insured who made the intentional material misrepresentation. The trial court's balance of the equities should have revealed misconduct by Sherman, but none by Progressive. The Court of Appeals concluded that the trial court erred by failing to recognize this distinction. By ordering the policy reform, the trial court placed the financial burden of paying PIP benefits on Progressive, notwithstanding the fact that Sherman obtained those very same benefits by way of fraud. The trial court erred when it ordered reformation rather than rescission, and its order was reversed. In my opinion, rescission is an ancient, equitable remedy that exists because it would be unfair to allow one party to a contract to profit from fraud in the obtaining of the contract of insurance. Sherman lied at the application requesting an offer of insurance about the location and available drivers, which, had she told the truth, would have resulted in much higher premiums, more than 80% higher. The trial court, trying to be fair, wrongfully refused rescission, but used another equitable remedy, that of reformation, to require the victim of Sherman's fraud, Progressive, to pay the medical expenses. Neither Ms. Sherman nor anyone should be allowed to profit from their fraud, and the Court of Appeals of Michigan set the record straight. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you will be given notice of every blog posting, usually 5, sometimes 6 a week. And if you subscribe, you'll also gain access to more than 4,800 blog postings. You can also subscribe to these videos on rumble.com and youtube.com, and if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com, and I'd appreciate it if you tell your friends and colleagues about these blogs and videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance law, insurance fraud, and insurance claims, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.